So that leads us to a couple of really important questions that members of the bar have to be struggling with, and I would think members of the bench would have to be struggling with, which is fee applications, right? A fee application where you would have seen 20 hours on document review and not thought twice about it on a piece of complex litigation. But now, don't you have to think, wait a second, you have Harvey licenses. Why are you spending all of this time? Is that a legitimate inquiry for a judge to ask at this stage of the game?
Yes and no, because usually those levels of analysis, at least for me, start with what did the agreement state between the client and the law firm. Because there is a very wide range of client and law firm. There are some law firms whose engagement agreement says, we use this unless you specifically tell us to opt out of it. And if you opt out of it, then you understand that there's going to be humans doing it and it's going to take longer. There's law firms that say we won't use it unless you say it's okay, and that will modify how many hours we spend doing it. And there's people who just haven't figured it out yet. And so, yeah, I mean, I have yet to have a challenge on it. It's also the question, just like, can you do, because some law firms still bill per Lexis search, or they upcharge the pacer fees and things like that. And then where does that line fall with the Harvey, subscription, or is it just becoming built into the hourly rate? Like, we're more efficient, so we can bill you at a higher rate, but we're not going to bill you expensive. I don't think it's shaken out yet. What I can say is I think it's really something that not everyone has taken a hard look at their engagement agreement. And there are some states which are mandating, and then some bars that have talked about mandating people either have a specific opt-in, opt-out, like you can't use it unless your client says yes, or your client specifically says I'm not agreeing with it. But I don't think that's also shaken down the path. So I haven't had the challenge yet. I certainly will, we look at fees for reasonableness, but we also look at the underlying agreement with the client. And there's with all of the questions about client information and confidentiality and how closed or closed circuits really, and how much does a Harvey subscription cost? Can my small practitioners just throw stuff into Chat GPT and call it good? Please don't do that. There's a line to be drawn, but a lot of it is still being fleshed out. Although I will say I was on a panel with someone about 6 months ago who is an executive at a very large Fortune 500 company. And he said that they specifically go into each of their outside counsel's agreements and say, you may not use it unless you previously disclosed it to us and we approve the use and we know what your system is. So clients are looking at it. I'm not so sure. Maybe people who are going into bankruptcy are as attentive to that as maybe those who are actually profitable and worried about long-term things, but it is becoming part of the vernacular on the corporate level, at least with respect to the use.
I have to think that a person who is being brought into a company as a chief restructuring officer, which of course we see all the time in complex Chapter 11 cases, is going to be sufficiently sophisticated to understand that that's a thing to consider in their engagement with Chapter 11 counsel. Do you feel like it's the role of the court to inquire as to the terms of the engagement agreement when considering a fee application?
And there's either an objection or a question raised as to, it's going to be easy to see from the charges whether or not they're back charging for a Harvey subscription, or from the entries which says review, put information into AI and review results. Like, those are things that are obvious for me. And if you always presume until proven wrong that when counsel files their fee application, they have reviewed their time records and that they're consistent with their representation agreement. And I guess for me, if the challenge comes in, Exhibit A had better be the engagement agreement, which substantiates the use or the non-use, or if that's the issue, we're going to have to see whether it was allowable or not. But I mean, other than that, probably not. But if it's an issue, then that's the first place you go, right?